At least since 2015, it has been described by court watchers as the secret shadow docket. And if you have never heard of the Judiciary Act of 1789, it would be a secret to you. However, some who take umbrage upon the executions of Isaac and Ethel Rosenberg, executed on Juneteenth, 1953, after being convicted as communist spies, are aware that this alleged secret shadow docket was a litigation vehicle used by attorneys that had been used to secure a temporary stay in their dates of execution that later failed. And probably its most popular uses have traditionally been used in criminal cases for prisoners seeking what is described as a writ of habeas corpus, translated literally as "you have the body," and derived from the Latin phrase referring to custody. And in jurisprudence, this writ is a court order demanding that a public official, such as a warden, deliver an imprisoned individual to the court and show a valid reason for the person's detention, establishing probable cause. Similarly, and primarily in family law issues regarding divorce, these writs may include writs or rules of nisi, which similarly result in an order to mandate to compel someone, some person or official in government to show cause for something that they have done, holding them accountable. And as the nation's highest court, the United States Supreme Court has an inherent power to ensure the administration of justice, which at times may require that they intercede and exercise a supervisory function to correct abuses amongst inferior courts. And this idea grew to a fruition during the passage of the Civil Rights Act of 1866, resulting in what is described by criminal defense attorneys as a removal statute that permits an accused criminal defendant to petition for removal of his state action in a criminal court to federal courts on a showing that discrimination exists during the prosecution of the case in violation of a statute that Congress had considered might be useful during the Jim Crow lynchings and the rise of the Knights of the Ku Klux Klan. And if you have been following the history of that removal provision, you know that it was improved during the Civil Rights Act of 1964 and recognized by the United States Supreme Court in Georgia v. Rachel during the integration of lunch counters in Atlanta in 1966. That case was decided. And if you've been following the press lately in the social justice advocacy realm, you may have heard about this secret shadow docket and the increasing use of this measure during recent years. But perhaps for causes that some may oppose and those not familiar with jurisprudence or the practice of law, often there is a perspective that is akin to attending a sporting event where our conceptions of justice is when our team wins or loses. However, in a rule of law, that same law that can be used for the team for which you were rooting is equally available to your adversaries under the idea that under the American justice system, all persons are equal under the eyes of the law and entitled to a fair trial and due process, regardless of our personal feelings. And that would be an evolved perspective on the justice system, which sadly most persons may not possess. But if you have aspirations for law school and legal scholarship, that is what is meant by the phrase learning to think like an attorney. And if you master those skills, it is quite possible that you will be guaranteed a lot of money, which is important to a lot of people because everybody loves a winner. And even if they don't, you can enjoy the luxury items that those who require your services will pay you just to get themselves out of trouble. And that is the way of the legal profession that one legendary criminal defense attorney had shared with me while I was still just a child as his protege. And that is exactly what brings us to the present application of what is now known as the All Writs Act, a part of litigation commenced in the U.S. District Court in Richmond immediately after the July 4th celebration weekend, and the very first litigation challenge that had been brought against the mandatory vaccines. Now, Since we initiated litigation in July, at least one vaccines case raising a claim of natural immunity has already gone to trial, been decided. And for whatever reason, in that case, the plaintiff had defendants who were willing to acknowledge the jurisdiction of the court over the case and sought to defend against the allegations with legal arguments and let the court decide upon the merits which party had brought a more meritorious case. And you might be asking what exactly the All Writs Act might have to do with the vaccines mandate. And since not even one litigation in the entire nation has raised this type of legal argument, you would not be at all alone in not understanding how this body of jurisprudence might find any relevance at all to being mandated to be administered a vaccine product, especially if you believe you have natural immunity or a religious exemption. So perhaps the best starting point would be to go back not to the beginning, but to the middle of the vaccines rollout, when on August 23rd, the COVID-19 countermeasure that Pfizer had been permitted by HHS to release under an emergency use authorization had been approved for private label distribution. And for those who may have been confused about why the Pfizer vaccine began to be called Comirnaty, a specially selected name that no other medication or product has, to avoid trademark dilution, and is actually an attempt after a collaborative research effort between intellectual property law firms and marketing experts, a process that I actually participated in while working in intellectual property law, to present three ideas in the minds of consumers of the newly approved commercial product: COVID-19, community, messenger RNA, and immunity. And that is what all companies do when they want to sell people a product. Yes, you have been sold a product skillfully designed to subtly communicate a fulfillment of your perception of needs or want, and to create a marketable product with greater potential to survive in the marketplace. A gain of function that a name like BNT162B versions 1 or 2, or its lesser known insider's name Tozinamarat could not provide. Comirnaty, a product born with a purpose or mission to attract your desire to make it your choice through natural selection. And if a commercial product in the marketplace has more will and purpose than you, my friend, you are its slave and it is your master. By August 23rd, the day of the approval of the vaccines, a topic of interest, at least by the reporters at NPR, provided a reason for a story idea that was first raised by that same reporter back in April: correlates of protection or immunity, which simply is a description of an empirical and purpose-directed method to determine in serological titers or blood samples the exact level of immune response the body is required to possess to effectively prevent an infection by a biological or even chemical agent from developing into a disease condition. This is going beyond immune response to the proper immune response. But on August 23rd, Dr. Anthony Fauci, the director of the National Institute for Allergy and Infectious Disease, had presented this idea for the very first time, correlates of protection, as a new potential method by which the COVID-19 countermeasures might be able to prevent those troubling breakthrough infections and become more effective than the current products being distributed by Pfizer, Moderna, and Janssen. And this brief discussion about correlates of protection was a significant announcement for the Comirnaty vaccine product and the folks at Pfizer, because the commercial product that would be rushed to approval by the FDA months before what had been scheduled for a mid-January 22 decision was approved not on the basis of an effectiveness test, the normal standard for approval of a new drug application, or NDA, but rather on the basis of a 6-month study for efficacy, or the ability of the new product to trigger an immune response, which may or may not be effective, which not until August 23rd did Dr. Fauci believe was appropriate to begin a discussion for the next phase of the product rollout, to make the substandard product more effective than the current product offering by Pfizer. Keep them coming back. And to a legal investigator, these admissions on August 23rd and their timing helped to establish what is known to moviegoers as premeditation, or mens rea to lawyers in criminal law, or a criminal state of mind. On evidence, this idea about correlates of protection was not even a novel idea to address a novel coronavirus, and the Comirnaty vaccine product approved for private label by the FDA, by NPR, and Dr. Fauci's delay in discussing this important method of developing a more effective product is indicative that there was a purpose for his delay tied to structuring the rollout for a new medical product in the commercial marketplace with a brand new name. Having begun in medias res at August 23rd, the coincidental White House briefing by Dr. Anthony Fauci on the topic of correlates of protection and the rushed approval for the Comirnaty vaccine product of Pfizer, we can go back now to the genesis or the beginnings of the idea of vaccine development, where this other concept of premeditation or state of mind or culpability becomes more important for establishing culpability under the law. And you may or may not be one who is any more familiar with correlates of protection than you are with the Public Readiness and Emergency Preparedness Act, or PrEP Act, codified in 42 U.S.C. Section 247D-6D. A statutory provision that dates back to 1944, but which was amended suddenly on March 27, 2020, under the provision codified at 134 Statutes 361, at least coincidentally, the very same day that former HH Secretary Alex Azar had published the Emergency Use Authorization Declaration, which had authorized the development of COVID-19 countermeasures to address, and this is important, what had been described as a product specifically to address a significant threat to national security, defined as members of the active duty military and citizens residing abroad from a biological agent. This declaration on March 27, 2020 is also of particular legal significance in establishing culpability or consciousness of guilt, because you may perceive some dissonance between the vulnerable population identified at the time for the unapproved products that had been released for an emergency use and the population to which the Pfizer product had begun to be distributed beginning in mid-December 2020, around December 15th, where the primary recipients, as designated by the CDC, were to be hospital workers and first responders, not the elderly population, which had been early identified as the population at highest risk even by the World Health Organization from the outset, but not even identified in the Emergency Use Authorization Declaration in March 2020, which focused on active duty members of the military and persons residing abroad, with no age specified. And at a time when discussions about herd immunity and natural immunity have become popular topics in the news, it might be a good time to discuss the PrEP Act, which was updated on March 27, 2020, the very same day of the emergency use authorization, and provided that, subject to other provisions of this section, a covered person shall be immune from suit and liability under federal and state law with respect to all claims for loss caused by, arising out of, relating to, or resulting from the administration to, or the use by an individual of a covered countermeasure if a declaration under subsection B has been issued with respect to such countermeasure. This statutory provision provided the immunity from civil suit for the vaccine product developers, who were certainly being proactive at a time when most Americans were being reactive to a global public health emergency described as a pandemic. Times that research upon which the nation's only physician serving as a state governor, Dr. Ralph Northam, had indicated were times historically associated with confusion, fear, and despair, affording an unconscionable advantage for a rational person who might wish to exploit those emotional feelings of the more vulnerable and compromised. But how effective is the immunity provided under the PrEP Act? And can it suffer a breakthrough infection itself, like the vaccine products about which Dr. Fauci was only discussing correlates of protection on the very same day that they were rushed to approval? Well, according to the PrEP Act, Section D, the sole exception to the immunity from suit and liability of covered persons shall be for an exclusive federal cause of action against a covered person for death or serious physical injury proximately caused by willful misconduct. So, under the PrEP Act, if you or someone you know has been seriously injured or died because of the COVID-19 vaccine products, the developers and certain persons who were involved in its administration and distribution can become defendants in a federal case by the injured party or their surviving representative. The PrEP Act does not make bringing a federal suit against the distributors of the COVID-19 vaccine products as convenient or accessible if the free vaccines and tests for infection. And Section E3, your attorney will have to take a look at, because you will notice that the PrEP Act sets up what is described by litigators as a heightened pleading standard and provides that the complaint shall plead, mandatory, shall plead with particularity each element of the plaintiff's claim, including A, each act or admission specific by each covered person specific sued that is alleged to constitute willful misconduct relating to the covered countermeasure administered to or used by the person on whose behalf the complaint was filed. Very specific. B, facts supporting the allegation that such alleged willful misconduct proximately caused the injury claim. Very, very direct. Not maybe, definitely. More likely than not, caused the injury. And C, facts supporting the allegation that the person on whose behalf the complaint was filed suffered death or serious physical injury. So in layman's terms, if you grab some attorney like Henning Jacobson did in 1905 in Cambridge, Massachusetts, to oppose the smallpox vaccine, and your attorney promises to take your fight all the way to the Supreme Court if necessary, if he decides to take your retainer and pump you up with hopes to encourage you to fight on, but goes into court with some farcical and specious argument about your derogation of rights guaranteed under the preamble, supported by your uninformed ideas about what vaccines and science work like, the court will say you were a sucker who wanted to give the car salesman your money and tell you to go make peace with yourself. So what must your attorney be doing to prepare his case in federal court? If you or someone you know has been seriously injured or died after voluntarily or being mandated by your employer to be administered the vaccines, under Section C3, it states that the plaintiff shall have the burden of proving by clear and convincing evidence willful misconduct by each covered person sued, and that such willful misconduct caused death or serious physical injury. Clear and convincing evidence is one of the highest standards of proof in civil litigation. And while it is not quite at the level of the burden of proof in a criminal proceeding beyond a reasonable doubt, clear and convincing means that you had better have your facts together before you step into a courthouse and pray for relief. And at Section C1A of the PrEP Act, it states that the term willful misconduct shall denote an act or omission that is taken, intentionally to achieve a wrongful purpose. 2, knowingly, without legal or factual justification. And I3, in disregard of a known or obvious risk that is so great as to make it highly probable that harm will outweigh the benefit. Those are the 3 elements of proof that a skilled attorney must convince a court by clear and convincing evidence if you or someone you know has been seriously injured or died after being mandated or volunteered to be administered a free vaccine that you were told was safe and effective at preventing infection from COVID-19. Vaccine products that Dr. Anthony Fauci knew on the day that they were rushed to FDA approval had been approved not on the basis of an effectiveness test, the usual standard, but rather an efficacy test, which to date is still in preprint. This may be important if your child dies after taking a vaccine and the superintendent told you that you had to. So having gone through a rundown on the secret preparations in which the vaccine developers, your elected representatives in Congress, and appointed government officials had engaged before attempting to market an allegedly free, safe, and effective vaccine product, we can begin to discuss the matter that we had filed on yesterday for the secret shadow docket, or so-called, and submitted to Chief Justice John Roberts at the nation's highest court, where, according to former Chief Justice John Marshall in Marbury v. Madison, had stated that it is the emphatic duty and province of the Judiciary Department to say what the law is, a supervisory function. Long before Dr. Fauci marketed as the nation's leading infectious disease control expert, which he is not, because the purpose of the NIAID is to approve funding for medical technology products. He's a drug dealer. Like the non-medical grade facial coverings that Americans were mandated to wear, even though which is the topic of our other litigation, now brought on appeal in a petition for certiorari at the Supreme Court, were determined a decade ago by the NIOSH with the same diagnostic equipment that is used to rate medical protection, like the N95, were battle ineffective under the science. We had submitted a request for production of documents from the White House under the Freedom of Information Act, which was acknowledged and accepted by the White House on March 23, 2021, 12 days after what has been called the American Rescue Plan speech, ARP, by the president, where he told the American people that he wanted to tell them the truth. He wanted to, and stated on the anniversary of the declaration of a pandemic by the World Health Organization that he carries a card in his pocket with a number of the Americans who have died from COVID-19 to date. That is on the back of his schedule, and that as of that date, the total deaths in America were 527,726. More deaths than in World War I, World War II, and the Vietnam War, and 9/11 combined. If you were to review the CDC website, however, regarding the prevention of COVID-19 infection, last updated on May 7, 2021, in addition to learning that the primary means of transmission is not by droplets but aerosols, rendering non-medical grade facial coverings totally useless, you would read the following statement. The infectious dose of SARS-CoV-2 needed to transmit infection has not been established. This is under the section titled Prevention of COVID-19 Infection. The infectious dose of SARS-CoV-2 needed to transmit infection has not been established. Infectious dose is a standard metric that has been used by epidemiologists for over a century. And it is a quantity that can readily be determined with very little effort, and is that exact quantity that must be known to develop an effective vaccine by measuring the appropriate levels in serological titers for the proper level and correlates of protection. That topic that first appeared on a slide at the White House briefing by Dr. Fauci on August 23, 2021, exactly 5 months after the White House had acknowledged receipt of our FOIA request. In our request, we did not ask what the infectious dose was, but rather had posed another inquiry that had been prompted by the fact that 1 year after the declaration of a pandemic, that quantity, at least not in the not-secret publications, had remained unknown. We simply posed the question as to whether the infectious dose was classified information, since the manner in which it had been presented by the official government sources and in the press had appeared to suggest that that was the case. A simple yes or no would have sufficed as a response on March 23rd, 2021, or any time thereafter, but rather the White House had elected a purported right to remain silent, which you normally only do in a criminal case, in violation of the provisions of the Freedom of Information Act. After the celebration of the 4th of July, Independence Day, the time at which the president had stated at his American Rescue Plan address 70% of Americans would have been vaccinated so that they could achieve what was described as herd immunity and enjoy a return to freedoms to assemble, gather with family, attend in-person worship, and celebrate holidays, and return to school, we filed litigation to compel the White House to provide a response to our question. But 1 week later, the federal district court in Richmond, rather than acting on its own, which it had the full power to do in its inherent power to compel the White House to provide a response, ordered us to amend our complaint, providing the White House yet more time to promote the distribution of COVID-19 vaccines. Our amended complaint was filed on August 13th, 10 days before the Pfizer product was rushed to approval at the FDA. And since that time, we have been unable to have the matter docketed for hearing to impose a temporary restraining order that would compel the White House to disclose whether or not the infectious dose for COVID-19 is classified information. A simple question, a simple response, yes or no. Perhaps to you, the determination as to whether this metric is classified information may appear irrelevant, or perhaps in full support of the government response to the public health crisis, you support the decision of the president to disregard the provisions of the Freedom of Information Act, a provision of law that had been enacted by Democrat President Lyndon Johnson in 1966 to hold the government accountable, and a provision of the law that the Democrat President Barack Obama had strengthened with his very first executive order, ordering government agencies to err on the side of full disclosure and stating emphatically that embarrassment was not an excuse for failing to inform the American people, who, the president had said on the anniversary of the pandemic declaration, had a right to know the truth. However, as a retired member of the intelligence community that the president had tasked to redouble their efforts to resolve the mystery of the origins of the novel coronavirus on May 28th, with a short suspense of just 90 days, I know, just as any member of the intelligence community knows, that under Executive Order 12958, signed by Democrat President Bill Clinton on April 17, 1995, the infectious dose for COVID-19 could only be classified information if that unknown metric, even over a year after the declaration of a pandemic, and with American fatalities now exceeding over 730,000, more Americans dying in 2021 than had in the previous year, could only be classified information if the biological agent causing COVID-19 was the property of the United States government that has mandated the American people to be administered a vaccine, closed businesses, schools, libraries, and churches, and that has greatly altered what had been accepted as the American way of life. And it is an unjust enrichment under the law when one engages in premeditation and actions reasonably calculated to take unfair advantage of vulnerable victims by creating the very conditions for which they pretend to offer solutions. This is for the purposes of the PrEP Act, defined as not negligent, but willful misconduct. This briefing is unclassified, as you were. My name is Major Mike Webb, and by God, I am running for Arlington Public School Board. Let's keep Mike Webb away from our schools. Honest. This advertisement was authorized by Mike Webb.
Thunk, I could have had a vaccine.